Good morning, gentlemen. Can you hear me?
Good morning,
Good
Judge.
morning,
Yes, it's
Bob.
me sitting. I can hear you.
And
Good,
lady.
good. And lady, do forgive me. Yes, of course. Now, I've got some background noise, um, and I think I can deal with that. I need a little technical assistance here.
Yes, Judge.
Ah, that's better.
Yes.
I've dealt with it. I've dealt with it. So, counsel are Mr. Dylan Malone and Mr. Banner.
That's right.
I can't see Mr. Albana.
Sabana is not available, and I have been brought in the picture for the pre-trial conference.
I see. Good. Well, thank you. I've not had you in court before, Ms. Khan. It's very nice to see you.
Thank
Very
you.
nice
Yes.
to see you. Now, I don't think there's anything very substantial on the agenda, Mr. Dillon Malone. Would you agree?
No, yes, Judge. I think the deviation was there were many deviations, but the net position is that we're just waiting to exchange expert supplemental reports on the
Yes,
12th of August.
yes,
And from then on, I don't know if you have before you the original case management order from February, the 3rd of February, and then the timetable kicks in again with today's case management review,
yes,
then the pre-trial review for the 6th of September,
yes,
then there will be trial bundles 2 weeks before trial. We have trial fixed for the 20th of September,
yes.
and the bundles and the chronology are due on well, the skeletons are due 4 days before the trial, but the chronology of significant events, the pleadings, witness statements, are all to be filed on the 13th of September, so in advance of the skeletons.
Yes. Yeah, remind me, how many days have been set aside for the trial?
3 days, Judge. I think my assessment at the moment is certainly in terms of the evidence and the expert evidence that we've seen so far from the other side is that's achievable
Good.
from my side,
Good.
because I believe the evidence in chief may be substantially relied on by us in terms of where we are. Um, that's not to say, of course, as you know, it's very difficult sometimes to predict with cross-examination, and I think a fourth day is sensible.
We do have that in reserve.
Yes, I believe
Yes,
so.
yes. Ms. Khan, do you agree with the view expressed by Mr. Dillon Malone?
Yes, I agree with the view expressed by Mr. Malone. As such, we are on schedule for the year trial.
Mr. Dillon Malone, is this essentially a contest between the experts?
No, no, I don't believe so. I think there are, perhaps at its core, yes, but on liability, no. That there is liability is in context as a counterclaim,
Yes,
and so therefore, in terms of liability, certainly it's the primary evidence that is key. And there are issues around the manner in which the dealings of the parties came to an end, which are ventilated on the primary evidence and may need a little bit of time uh, to explore in evidence. So, but in terms of the quantum, very largely, yes, of course. There are certain commercial aspects on our side. Mr. Abkhaziev is our non-construction expert. He's our non-construction side primary witness, and
Yes.
he's there to give evidence on the commercial side of things. So he would want to give some evidence relating to quantum in terms of the impact on the business of these events. So I think that's the shape of it. But,
Yes.
but you're correct, Judge, that I think the focus of quite a lot of the hearing will certainly be on the expert position.
Now, I think I have it right that you liquidated two performance guarantees or other forms of security.
That's correct.
And that, of course, comes into the overall account so far as your claim for damages are concerned.
Yes, indeed.
Now, how many factual witnesses are you calling?
We're calling two factual witnesses. The one that has delivered our primary evidence in terms of the construction project and what happened on site is Mr. Resk, Mr. Mustafa Resk. He's the project manager. And then our second witness is Mr. Abul Qasim Prokaziev, and he will be giving evidence on the commercial side of things.
Yes.
Including the property loss. Then on our expert side, we have two experts. One who is devoted to quantum of the construction loss and delay aspects. And then the other is purely on the loss of income on the property side, divided between rental on one analysis and sales on another analysis, on an alternative analysis. And that's Mr. Richard Paul of Savills. And our expert for the construction loss side is QSI expert, Mr. Brian Allen.
Yes, thank you. Ms. Khan, can I ask you the same? How many factual witnesses are you calling?
We have one factual witnesses and two experts. One is on quantum and one is on delay. And yes, the factual witness statement is about Abdul Aziz Ibrahim Al Kirdi. That's it, one witness.
Might I just ask, Judge, that is a change, as there was just a single expert witness that was notified to the court. There's a single expert witness that has given the delay and construction side analysis, and the court has not given the defendant leave to adduce expert evidence from any other expert. So that is new.
I could correct that. We have one expert, but he has submitted two separate reports. One is on quantum and one is on delay. So I should correct.
Thank you very much, Ms. Khan. Excuse me.
Thank you.
Well done, Ms. Khan. Yes. Well, is there anything else I really need to know at this stage about state of preparation and the likely length of the trial? Ms. Khan, do you have anything you'd like to draw to my attention?
As such, no, Your Honor, we would definitely take the normal time for for the expert and one witness, but there is nothing that is pending or which should be brought to your attention.
Thank you very much. Anything further, Mr. Dylan Malone?
There were just one aspect which it's just to say that the expert report that's been delivered on the other side, the expert reports do not in terms address the property loss side of things. Now that's what it is. It may be, and I just only flag this because it could be likely that if and to the extent that the expert response addresses the Savills report, that will effectively be the first time that the defendant will address the income loss side. And depending on what is said, if anything, it might be that we would look for an opportunity to respond to that with Savil's responsive comments. I'm not saying we will, and I do not know what will be said on the other side. But if we did that, I would endeavour to propose. I'm not saying a direction is needed now, but because it really depends on what comes. But if that did occur, I think we could fit it within the existing timetable, and we do our best.
The reply or supplemental expert reports, I think you said the 7th of August?
The 12th.
I'm sorry, the 12th of August. And this is due to be tried. What's the trial date again? It's late in September, isn't it?
20th of September.
On the 20th of September. Yes. Well, we'll have to see how things develop. If you're going to apply, and I think you'll need to apply, but it can be a letter application to adduce a responsive report to anything going to the property losses. You're going to have to get your skates on.
Yes, indeed. Absolutely.
Yes. All right.
Thank you very much for that indication.
I think that probably that concludes matters.
I believe so.
Thank you very much.
Thank you very much, Judge, for your time today.
Thank you very much, Your Honor. Thank you.
Thank you.
Good. Now I'll just have a word with Mather. Mather, you're presiding over this short hearing.
Yes, Judge.
Is there anything that the registry would like to remind me of before we finish?
No, Judge. No, that's it. Thank you so much.
Right.
Okay. Just before we leave, I'm sorry to raise it. It's just it was in the back of my mind, and it's something I could be mistaken on this, but I'm not sure whether the corresponding fees have been paid for the counterclaim in the case. And I raise it hesitantly. I know it's not a matter for you, but there is an equality of arms concern from my client who raised it with me recently. And I just raise it here. It needs to be addressed by you, but perhaps
somewhere in the back of my memory, it was to do with dealing with two parallel pieces of litigation, in a sense, becoming one. And I think there was a provision for the waiver of a fee in respect of something or other. Maybe Mather can help us. In other words,
Yes, Judge. In relation to the counterclaim, I believe the defendant have settled the payment.
the defendants settled the payments for the counterclaim.
Yes.
And are there any outstanding fees?
No, I don't. No, I do not believe that.
Okay. Thank you. That's my mistake, Judge. And I say I hesitated to raise it, but I'm very grateful.
All right. Well, thank you very much. I'm going to close down the hearing now. Thank you.
Thank you. Thank you, Ms. Khan.
Thank you.
Thank you.
Thank you. Thank you, Patrick. Thank you.